I knew you'd enjoy it. May 24, 2018, Town of Nantucket Board of Appeals meeting. Can I get an approval of the agenda as written?
So moved.
So, a motion to approve, I meant to say. I mean, Lisa made the motion, Michael seconded it. Any further discussion? No. All those in favor say aye.
Aye.
Okay. 5103, Rugged Scott LLC, Rugged Scott, a.k.a. Beach Plum, 40B, for the applicant.
Mary Ann Hanley for the applicant. I just want to follow up on some points that were raised at the last meeting, and I just for conciseness and my own sanity, I was just going to read basically some information. Here's a copy. I believe I have enough for everybody. I might not have a here. I didn't think he was on this. The last meeting we were talking about how the garage easement on lot 24 not being able to resolve it would make the project uneconomic. As per our many discussions, our view is that the garage easement on lot 24 to benefit the owner of lot 23 didn't require your approval. The history and context for this was described and discussed at length in the summer of 2007 at ZBA meetings in June and July, and you are also provided with materials quantifying the relative impact of all easement areas on affordable lots. For instance, Lot 10, which does not have a garage easement, has 4,065 square feet of uneasemented area.
Sorry. Let me just get Eileen on the phone, if you don't mind. We're getting into areas that are probably beyond us. Okay.
Your call has been forwarded to an automatic voice message.
Never mind. Go ahead.
Okay,
Sorry,
so as I
Mary Ann.
said,
Go ahead.
Lot 10 has 4,065 square feet of uneasemented area. 24, which is the subject, and has a garage, has 3,935 square feet of uneasemented area. And I'm not sure uneasemented is a word, but it's the best I could do. And lot 33, which does not have a garage easement, has 3,951 square feet of air, uneasemented. The differences are minimal. The garage use easement areas have not hindered the construction and occupancy of the affordable dwellings, nor have they created any inconsistencies with the local needs under the purview of the ZBA. Notwithstanding, the ZBA still had concerns, and as requested by the ZBA's 40B consultant, Ed Marchant, Rugged Scott formally requested a modification to the comprehensive permit, the form and content of which modification was negotiated with and accepted by Mr. Marchant prior to its submission. At the board's September 2017 meeting, the ZBA determined the matter was not insubstantial. The applicant reserved its right to appeal that determination, and the public hearing on the modification has been ongoing since September. The approved garage on lot 24 was built in 2015, and the building permit application and the plans submitted for that application referenced that it was to be used by lot 23. Prior to the construction, similar easements had been granted without objection from the ZBA, the monitoring agent, or the attorneys representing the purchasers of the lot subject to the easements. Being a condition of sale, the garage easement in favor of lot 23 was formalized at the May 24, 2016 closing. As background, the right to use a garage was critical to the purchasers of lot 23. They wouldn't have purchased the house without the garage. Economically, selling lot 23 was equally important to the Beach Plum project. Just like everyone else in the country, Beach Plum was clobbered by the impact of the Great Recession. There were no sales in the subdivision from 2011 through 2013. There was only one sale in 2014. Sales started to pick up in 2015, but not enough to make up for previous years. And in the spring of 2016, Rugged Scott knew that it was crucial to generate more market sales in order to offset construction costs of the affordable units. By being able to provide a garage for Lot 3, that was what made a critical market rate closing happen just before Memorial Day weekend, not only enhancing the prospects for the summer marketing season, but more importantly, providing substantial and needed capital for the project. Several months later, the sale of Lot 24 commenced. Throughout that process, the existence of the easement in favor of Lot 23 was fully disclosed to the purchaser of Lot 24, and the physical use of the garage by the owners of Lot 23 was visible and ongoing. Having full notice of same, the purchasers of Lot 24 entered into agreement to purchase the property with the existing easements in place and closed the sale on December 16, 2016. At its most basic level, a denial of the requested modification will make the project uneconomic. The process of undoing the easement between the owners of lots 23 and 24 is not within the control of Rugged Scott and is not possible without the cooperation of the owners involved. Through counsel, we have been informed that the owners of Lot 23 are not willing to forego their easement rights and that the owners of Lot 24 want those rights terminated. Litigation will most likely ensue, and costs, which will be substantial, cannot be fully quantified until a final outcome is reached. As the ZBA is well aware, the expected financial results of Beach Plum's development will be well below the threshold of economic viability, as will be confirmed by the cost certification process required at the end of the project. At best, given the time delays and depressed prices caused by the Great Recession, Rugged Scott anticipates that the project will break even, although costs not previously anticipated regarding garage easement modifications have not yet been added into that calculation. Finally, as you're also aware, in order to resolve this matter, Rugged Scott negotiated an agreement with the owner of Lot 24 last winter, wherein a series of significant improvements would be made to the house on Lot 24 in exchange for the support of the Lot 24 owner for granting the proposed modification. The agreement was negotiated in good faith between the parties, memorialized with plans, and a written description of the improvements was exchanged and confirmed by her then attorney. The agreement was confirmed by the Lot 24 representative at the January ZBA meeting, and the decision to grant the modification subject to the agreed-upon terms was continued to February, when final HDC consents to the proposed work would be available. However, at the February meeting, the Lot 24 representative stated that she was engaging new counsel and that she was not willing to adhere to the agreed-upon settlement. Since then, she and two other subsequent attorneys have promised to engage in discussions and earnest efforts to resolve her concerns, but communications to them have been generally unanswered. We were, however, recently informed that through counsel that a contractor friend of the property owner claimed that the agreed-on basement access plan might undermine the existing foundation. That claim's not accurate, and through its architect and engineer, my client is still happy to review that concern with the Lot 24 owner. Should the board wish to condition its approval of the modification request upon the completion of the work previously agreed to by the owner of Lot 24, that condition would be acceptable to Rugged Scott. We urge you to approve this modification request. Request of relief is consistent with local needs, and failure to approve the modification will render the project uneconomic. For your reference, I think we've already given you this before, but I've also attached a list of the Lot 24 improvements. The one at the bottom about this planting has already been done. If you have any questions, I'm happy to answer them.
Okay, thank you. So is anyone else in here to talk about this specific issue? No. Okay, thank you. So all we need to do today, if we're in agreement, we don't have to take a vote on the issue. We just need to vote to close the public hearing, in which case then we have a certain number of days to render a decision. We can debate the points with Marianne. It doesn't appear that the other lot owner is here. So, and those discussions have seemingly not borne any fruit. It's been a long time. So, well, how do you feel about this whole?
I'm probably as sick of it as everyone else here. One thing that was never clear to me, as clear as I would have liked to have been, is whether the buyer of Lot 24 ever agreed that they didn't know anything about the garage prior to their first encounter with the property.
Well, they're not here to speak to it, so
I know it's been said, but I was never got the impression that there was any agreement on that issue.
Yep.
I can't speak for the owner of Lot 24, but I do have the purchase and sales agreement that was signed for the closing. And one of the provisions in the agreement said that the property would be subject to the following restrictions, one of which was a grant of easement dated May 19, 2016, recorded in Book 1539, page 266, providing access and exclusive use rights of the garage upon the premises to the owners from time to time of 14 Blazing Star Road, Nantucket, shown as Lot 23 on Plan Number 2006-61, currently owned by Lauren Cuneo and Andrew Cuneo. It was in the purchase and sales agreement. It was, I dealt with counsel on it. I've never dealt directly with it.
No, I knew it was in the purchase and sale agreement.
And you did deal with their counsel on it? Their the buyer's counsel?
We negotiated the purchase and sales agreement. He didn't question it.
And was this the one we had the correspondence at closing between you and the counsel about this easement here?
No, that
That
was
was the other one.
That was another one. No, we were never informed that it was an issue, and then frankly, until we filed the application.
I think the
You're at the
implication
closing.
was that, and again, that's all it is. Forget it, it doesn't matter what the implication was.
Would there be actual numbers that show that this is uneconomic?
Yeah, well, again, Marion or Rugged Scott making the assertion that this is all uneconomic and that we're aware of how it would be uneconomic, or that we're aware that the threshold of economic viability is going to be crossed by this. I mean, we're not aware of anything because we don't have any proof of anything to that extent. And your assertion that you can't give us any numbers, which is fine, it's up to you, because you can't factor in the litigation costs. I mean, again, I think we would have certainly accepted an estimate of the litigation or legal costs rather than just say, we can't give it to you, but you should be aware that it's uneconomic. So that, I don't know what else we can do about it, but I agree that we should probably have had some figures
Yeah.
if you're going to make the assertion. So
Giving you final figures when we don't have the project completed, it's
But
difficult. I don't want to guess.
well, you have at the beginning of the project, you have a pro forma that states that this project is going to make it. I mean, that's what you base the project on. You
Right.
base any project on projections. So you have numbers up to today, and then you would project out the rest of them, obviously. And we would either accept or not accept or question the numbers or whatever. But for whatever reason, you don't want to produce that information, and that's fine. That's your prerogative. But, I mean, to say that we should be somehow make the assertion that we're aware of the economic viability or non-viability of this project, it's just, we have nothing to
We have
base
no
that on.
idea.
We have no idea.
we don't know how much it costs to build the houses versus how much you sold them for. I mean, we have no idea.
So, I mean, ultimately, it would seem that if it, depending on how a vote goes, if it were, you'd have to prove that elsewhere. So that's up to you. But we've asked and we haven't been given the info. And I don't see the owner of Lot 24 here asking to continue this yet again. So, I mean, my inclination would be to close the public hearing and then we can discuss a vote. I would prefer to discuss a vote at a later time. Is that okay with everybody?
And it's not at a public hearing.
Well, it wouldn't be a public hearing. We wouldn't be accepting a testimony or debating points with Mary Ann. We would, or
We'd just
Rugged
be
Scott in
discussing.
general, we would just discuss it and take a vote one way or the other on the modification request, which is all we're really talking about. And then if it gets settled, well, it doesn't matter. So how does everyone feel about that issue? Closing the public hearing. Yeah? Okay.
Sure.
So for the purposes of moving on, can someone make a motion to close the public hearing as it relates to the request for a modification. I mean, I wish Ilana was on the phone to put that in better terms,
Should we
but
try again? Just one more time?
I think that ship has sailed for now. Eleanor, do we have to do anything special in terms of a motion? Do we
Well,
have?
if you want to do it exactly sort of verbatim the way she had you do it for lot 27,
I would.
I may be able to locate that motion if you give me a second.
I will.
That was closed in February?
No idea.
She's doing that, Mr. Chairman. How long do we have to act on this after we close the hearing?
40 days.
40
So the
days.
decision has to be written.
So that we discuss it at the next hearing,
Right.
which is June.
14?
It's the 13th, I think.
Right, we'll have to take it up on the next regularly scheduled meeting,
Yeah.
which is 2 weeks from now.
Yeah.
Right?
Okay. Decision would have to be rendered within 40 days to close the public hearing. And then we have 14 days from that point to file the decision with the town clerk's office, just for information. I can't find it, but I would say that the motion should be to close the public hearing as it pertains to the request for modification regarding lot 24. And then, flesh out the details of the request to allow a garage to be sited for benefit of an adjacent lot in a garage use easement. I can find the language in a prior
The
email.
request was just to show the garage easement, the lot was already there on the plan.
Okay. Well, we have two choices here. We either, if we're comfortable with just a generic, if you will, motion to close the public hearing, we can do that now. We could, another option is to continue this to the June 13th meeting, in which point we could not only close the public hearing with a properly worded motion, and we could also then discuss the vote and take a vote at that time. In other words, I'm not.
If I might, we're not going to offer any new information.
No, I know.
We're perfectly fine with the generic closing the public hearing on this matter.
I know you are.
I don't see what your concern is about.
I don't have any.
Public hearing.
I don't have any great concern, quite frankly. But I like, because you have mentioned that you plan to litigate it. I just want to.
No, I don't plan to do that.
Well, if,
I don't know what the decision will be.
Good point. If indeed it doesn't go your way, all I want to do is make sure we're crossing the T's. So I think that I'm fairly comfortable with the motion to close the public hearing as it relates to this matter. I think that motion is sufficient. How does everyone feel about that?
Fine with me. By closing it, we're not foreclosing our opportunities to get advice from Alana on what our options are.
No, I don't think so. Let me try her one more time just to. Will you just confirm I have the right number, Eleanor? 617.
7550674.
Oh no, yeah, that's probably part of the problem.
I thought you had your eyes off.
Right, I put it in wrong.
You put it in the wrong spot.
What'd you say?
Atlanta Clerk.
Hi, Ellen, it's Ed Toole. I apologize.
I should fix your
No
things
worries.
right now.
I tried to call you earlier, but someone put the wrong numbers in my phone. Anyway, to make a very long story short, we are discussing Rugged Scott, the garage situation on 23 and 24. We've gotten to the point where we would like to close the public hearing. Does that have to be, do we have to be concerned about the language of the motion in that regard?
I would use language that's similar to the language that you used the last time. And there was an issue with these remaining garages you had asked for pro forma. And my understanding was that the developer had indicated that one either was being prepared or that an answer would be had on that at some future date.
Okay, well,
was the next.
no, I'm going to summarize because I was too inept to put your number in properly and dialed the wrong number. So the developers council has read something to us that basically makes the assertion that the project is uneconomic or would be rendered economic, but doesn't provide any sort of pro forma evidence to that effect. So, and doesn't seem interested in providing that. So we're I guess, beyond that point. So I think the board.
Okay, so they've been given the opportunity and they declined essentially, and instead of giving you the full forma that you then would have the opportunity to have peer reviewed, they chose instead to just give you a conclusion that it's their conclusion with no evidence. I mean, obviously, I assume that whatever they gave you doesn't go through any numbers to say, look, this is what it cost us, and this is why this puts us over the edge.
No, there are no numbers. They're just the assertion that it renders the project uneconomic. So I think the board is ready to close the public hearing in that regard.
I did find the motion for you, I'm sorry.
Okay, then you can go ahead, certainly if you're ready, the board's ready to go ahead and close the public hearing. You have another meeting, obviously, in early June. I can prepare a decision for you if you would like, if you want to authorize you to do that. That would be very similar to the one that you did the last time, which is, the changing the names, the lot numbers and so forth. And adding in, as Eleanor had said to me, the latest letter that you asked for, for a pro forma and didn't get one, and so no proof was offered as to, to establish that it would render them uneconomic. I'd be happy to do that if you'd like.
Yeah, I mean, that doesn't, yes.
And then, I can have it ready for you to review before your next meeting, and then you can vote on it at your next meeting.
Okay, perfect. So, Eleanor, would you read back that motion from the last time?
I'm tailoring it to this particular lot. Motion to close the portion of the pending, we don't need to say pending, because this is the last portion of
I
this.
can't hear actually.
Yeah,
Here. This way Eileen can hear it.
You can speak in right now.
Motion to close the pending public hearing regarding developer Rugged Scott LLC's modification request to amend the comprehensive permit decision and approved plan of record to allow a garage on Lot 24, an affordable parcel, and to be used for the benefit of Lot 23, a market rate parcel, and regarding the related easements that have been requested.
okay, thank you.
Yeah, that's fine.
That's fine. Okay, so will someone,
You could go on and okay, never mind. You can go ahead and do that. You might want to also authorize council to write a decision, but you haven't indicated to me, what that decision would be. So you would need to tell me.
do we need to tell you at this time?
Well, do you want me? I can write a positive decision to grant the relief. I can write a decision to deny the relief. I can do it in the alternative so that you have choices.
I think what we would be interested in is choices. I don't think,
Unless
The alternative,
it's cut and dry. And
right.
normally we would do the motion in the affirmative and vote it down or vote for it.
Yeah. My thought was to close the public hearing and then discuss the vote at the next public hearing. And in which case we could certainly, I think the choices option would be best at this point. Is that how the board feels, or are we pretty set one way or the other?
That's how we did it before.
Yeah, I'd like some,
Well, you do need to close the public hearing.
Right.
Before you vote on how to dispose of the matter. I mean, if you did it all in one motion, if you're ready to do that, that would be fine. At this point, I would go ahead and close.
Yeah, that's what we wanted.
So why don't I make that motion?
Okay, so Lisa makes the motion as Eleanor recited it. Yeah, is there a second?
Second.
Kiram seconds it. Any further discussion? No. So the voting group, you voted on the last one.
I don't think Karen has been consistently present for this, so it might be better
Okay.
not.
So Kiram did not second that. Can someone else second the motion? Jim seconds the motion. Okay, so the motion was made by Lisa, seconded by Jim. So it's the 5 of 2, 4, 5. Okay, it's going this way. All those in favor say aye.
Aye.
So Jim,
Jeff,
Michael.
Michael, Edward, and Lisa. Okay, so the motion is carries unanimously. Okay, so now do we need to we don't need to continue this matter to the July 13th meeting, do we? June.
June. No, you don't need to continue. You just close the public hearing, so that's all set. But you can certainly authorize me to, go and prepare a decision, and I'll do it in the alternative, to grant, to deny, to brief, and then you can pick and choose and do it at your next meeting. Because the problem is that from this point forward, you have only 40 days to make your decision. So I want to get the decision draft to you as soon as possible.
Yep, that works.
I know that,
What's that?
40 days goes pretty quickly.
Yeah, so can I get, do we need a motion and a vote on that matter, or can I just authorize you to do that?
You can certainly authorize me to do the decision in the alternative in the event that it were to be a direction for council to prepare a decision that was negative to deny the relief or to grant the relief or to grant it with conditions, then you would need really a motion for that and a vote.
Okay, so having said that, it sounds like, did everyone get that? It sounds like we'd like a motion to authorize town council to draft at least two motions, one in the negative, if you will, one positive, and what else?
does council think that
And that's
there
fine.
should be a third?
That's fine.
The third would have been one with conditions, but that can be the positive. We can discuss that, I think, at the time.
Yeah.
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 Okay. Let's. So, Lisa, will you make that motion?
Sure.
Lisa makes the motion. Jeffrey, or Jeffrey,
Second.
Jeffrey seconds it. Any further discussion? No. So the same voting members. All those in favor say aye.
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 That was unanimous. Okay. Thank you. All right. So moving on.
Susan?
What's that?
Does Susan need to come back in?
I'll get it.
Okay. Okay. So now, once Susan returns, I'll wait a moment. Oh, okay, thanks. Okay, so now we're on to 2018 Surfside Crossing LLC, Surfside Crossing 40B for the applicant, please.
Mary Ann Hanley. It's my understanding that you're going to run through your list of peer
Yeah.
review people, so I'm not sure how you want to do this, Ed. If you want.
Yeah, I guess we'll just,
We did send over an objection to two of the persons on the list, or two of the firms. One is Horsley Witten, and the other one is John Chesia.
and what were your specific,
Horsley Witten, the conflict issue, they represent the Land Council, and they're actually listed on the Land Council's website as, doing their work, and, they've asked their donors to fund them so that they can continue to do more work with them, and the Land Council has already hired attorneys and has actually appeared at the last meeting in opposition to this project. And then on the flip side of it, Peter Freeman, who's also counsel to our project, is working with Horsley Witten on several other 40B projects, and he said there should not be any.
Chairman, I really can't hear any
all
of
right.
it.
Is your mic working?
She said it is.
It is? Well, no, Ilana can't. Maybe if I turn the phone.
Problem with that one is I can't hear it out here.
Should I try this?
Try that, if you don't mind.
Ilana, can you hear that?
Yes, I hear that.
Okay. There was a problem with the mic.
Can you hear me now?
Can you hear Marianne now?
Thank you.
Yeah,
Okay.
thank you.
That's better.
Okay.
Okay, on Horsley Witten. First of all, they have a conflict. They do all the Land Council's work. They're listed on their website as, asking people to donate to them so they continue to can work with Horsley Witten. And then Peter Freeman, who's our counsel on this project, is also working with Horsley Witten on several other 40B projects off island. And he said there should, even the hint of impropriety that Horsley Witten might be doing something in our favor because of their affiliation with Peter on those projects is not acceptable. And then the second objection was Mr.
Still really hard to hear.
Okay, I'm going to summarize that on the Horsley Witten issue, Marianne is making the assertion that there's a conflict. The Horsley Witten works with the Land Council, who has objected to this project. I don't know if they've objected to it as much as they commented, but anyway, they're on the Land Council's website, et cetera, et cetera, et cetera. And secondly, the Horsley Witten is working currently with Attorney Freeman on several other projects off island, and they don't want any hint of or implication that there might be a favorable look at the project based on the relationship. Okay.
Well, certainly, I understand, I guess, what's being said. Certainly that would be for the board to determine as to whether that appears to be a problem. It doesn't, off the cuff, sound like a problem to me. In the event that Horsley Witten indicated that it could, move forward fairly and impartially, perhaps they would determine that, they have some kind of interest that would concern them, and if they did, then they would say so. It's not leaving off the page at me. Has anyone talked to Horsley Witten on our side as to whether they think they have a conflict? Have we disclosed who the applicant is?
Yeah, we did ask.
If I may, through the chair, I have reached out to the firms that are in the list, and I've spoken directly with every one of them, and they all, including Horsley Witten, assert that they don't have conflicts. Horsley Witten in particular, I spoke with Brian Kuchar, said that they're aware that their work with Satan's Path might appear to be a conflict, but that was the only thing that they brought to my attention. They feel that particular work in the past would not present a conflict. They did not bring up the NLC association. The other thing that was brought to my attention.
I'm going to summarize again. We've talked. Eleanor spoke or sent a letter to each one of the potential consultants. All have asserted that they don't have conflicts And Brian Kuchar at Horsley Witten did bring up the association with the Sachem's Path project as, I think, just to let everyone, he didn't feel it was a conflict, but he wanted it out there that they did work for that group. Now, I don't see why that would be a conflict. So now I have to
That's the work is done, though.
I have to ask Eleanor, were they aware of who the applicant is?
They know that it's Surfside LLC, and in the documents of the application, there is, the LLC certs are in there, and you can see who the principals are for the LLC. Some companies asked me who was behind the LLC, they did not, which
Okay.
either means they weren't worried about it, or they figured it out themselves.
Okay, so to summarize, did you hear that?
I need a summary.
Okay. To summarize, it's not 100% clear to me that they knew, although the LLC docs are in the submittal, which say who are the LLC principals, but I don't know that Attorney Freeman was listed in those docs.
Well, he's listed in the team in.
Okay, he's listed as part of the team. So the assertion is that, and again, I'm not saying we've agreed to this yet. The assertion by the applicant is that Horsley Witten's association with Peter Freeman on other current projects may be a conflict. I don't necessarily see it that way either, but we'll get to that.
Yeah, the issue would be whether there's a conflict with the applicant and
Yes.
whether there's a relationship that is of concern to the board, because even in a situation where there is the potential for a conflict, if it's disclosed and all the parties agree, then it's not a problem.
Right. So we'll get to that.
Again, not leaving off the page at me. Okay.
As Alana said, the decision as to who the conflict is with the applicant. And rather than have to file an appeal, you've got six other firms on here that we have absolutely no objection to, and in the spirit of working cooperatively with the applicant to identify appropriate consultants as is required
You speak into
under the
mic.
regulations. Again, we feel that Horsley Witten does have a conflict. The Land Council has sent out a writing opposing this project. They've hired counsel. Horsley Witten works for them on this paperwork, that Eleanor sent out is, have done work for the Land Council. And, also the fact that they've worked on Sachem's Path next door could influence what the outcome would be on this. And we don't, it's our conflict. We're not willing to waive it. And again, as Mr. Freeman said, he said, I do not want the hint of impropriety to taint this proceeding. And he said, we cannot, because of my affiliation with Horsley Witten on other projects, he said, we cannot agree to it. So I would ask you to take that into concern and look at your other list. Do we want to go on to the next objection?
I think so. Or do we want to discuss?
Or do you want to,
Discuss it.
I don't know how you're planning to discuss.
Well, can we have time to reach out to another? Do we only reach out to
No,
one?
Oh yeah, no, they're multiple.
No, there's a whole bunch on the list.
You'll see in the staff report.
Yeah, no, they're multiples. Right
is
now,
it in
the
the
applicant, ultimately, we would have to decide whether or not we think it's a conflict. And then if not only we decided it's not a conflict, but we wanted to hire them, the applicant has the right to go to appeal to the Board of Selectmen, of all people, to figure this out. And that forestalls the time clock on this. 180 days is the forestall is probably not the right word, but the clock stops.
It's for 1 month.
Yeah, it stays it for the.
Potentially for up to 1 month.
So anyway, that's what we would have to decide. Not only is it not a conflict, but those are the guys we want. So why don't we move on to the next objection, and then go ahead.
Eleanor, do you know what page it is in the packet?
There's a table of contents with the packet.
There
I don't
is?
have it in front of me, but somewhere like.
Which,
I have the list. I just wanted to make some notes. I have the list on the iPad, but I wanted to see it in the packet.
oh, I got you.
What page is it on the?
As I said, there's a table of contents in the packet.
I don't see a table of
Which
contents.
has exactly where the peer review materials are towards the end.
I think it was started page 266-ish.
Okay, thank you. I didn't see the table of contents when I was looking through it. Here it is. Got it. Thank you.
Okay, so let's just table that for a moment, that objection, and then we'll go on to the next.
Okay. The next one is Chesia Consulting Services. This has more to do with, it's difficult to make a decision based on a lack of information that's here. It's not apparent, although this is a long resume and it says a lot, it doesn't really say anything. And frankly, if I were looking at this resume and thinking about interviewing this person, I probably wouldn't, especially in comparison to the information that's been provided by everybody else on the list. There's nothing here to indicate, and I don't think that anyone here has any familiarity with him. We don't believe he's done any work on Nantucket. There's nothing to indicate that he's done any work on the Cape and Islands. So it's very important not only to my client, because the peer review has to be done properly and correctly, but I think it's also important to the board and everybody else in this room that the people that are doing the peer review are familiar with Nantucket. They know, not just knowing that it's a place on a map.
Well, I definitely don't agree with that, but
Well, can I finish?
yes.
Thank you.
I thought you were.
Several of Cape and Islands familiar with the geography, with the topography. Somebody that's worked in Greenfield, Massachusetts all his life is not probably going to be the best choice for something here. I have no idea if Mr. Chesia worked there, but I'm just saying that's the example. Everyone on this list, Mr. Pesci, Haley and Ward, West Beta, I think they're called, Beta Group, Weston and Sampson, Vaness, Tetra Tech. They've all dealt with seaside communities. Beta Group has been stuff in Barnstable. They've also dealt with a lot of seaside property in Rhode Island, Bristol, Narragansett, Milltown, which has a lot of the same concerns as this island. So it's important that like you said, 40 days goes fast, well, 180 days goes fast. So it's just better to have a consultant, and you've got several on this list, that can hit the ground running, that are not going to have to start from scratch to review all of this and to make it all work and make it worthwhile. To the extent that some of these people, I know Vanessa is here working on the in-town bike path. They're here all the time. They can be available. They can answer questions. They've been through records. They're not going to have to put the burden on the town offices. Like Mr. Chesia is going to have to says, well, I need to talk to the water company and I need to talk to the sewer company. And, basically, if the water and sewer people are qualified to make decisions and to assist him, they should just be doing this. They shouldn't be sent out for peer review. So we feel that given the list of candidates here, you've got 6 candidates that are very good, that are very qualified, that we have no problem with. The other 2, for the reasons we've mentioned, we would suggest that you not use them.
All right. Well, did you hear that, Ilana?
What I think I heard I heard something about Beta Group, and then I heard something about John Chesia and something about.
All right, I'm going to summarize. I'll summarize if you don't mind. Rugged Scott is, or not Rugged. The applicant's making the assertion that John Chesia does not, lacks any local knowledge, and that somebody with local knowledge should be doing the peer review versus somebody without, because they're going to have to, quote unquote, review everything and get up to speed. My personal feeling about the notion of reviewing everything and getting up to personal speed is I thought that's what the consultant's supposed to do. is review everything. And
And that objection is not one that would give rise to a successful appeal, in my opinion, under 4453G. The only two bases, that can be put forward to appeal the selection would be either a conflict or the fact that the person isn't qualified, doesn't have the minimum requirements, which I believe are either 3 years in the field, or there are very specific requirements and they're minimal. And the fact that someone does not have familiarity with the particular land or conditions would not be a basis to object. It's something that the board can take into consideration. If the board has a concern about it, an independent concern about it, that's perfectly fine. But that's not something that could give rise, in my opinion, to a successful appeal under Chapter 44, Section 53G.
the appeal that Alan is referring to is the appeal to the selectmen. It's very specific as to, what you can appeal. The conflict or, you don't meet the minimum standards. So anyway, having said that particular applicant, have you had experience with him?
With John Chesia?
Yes.
Yes, extensive experience with him. I've hired him, or had clients hire him, and I've hired him as an expert in a number of cases, particularly when drainage is an issue. And he has testified, not for me, but for other attorneys before the HAC, leading to two successful decisions on behalf of municipalities. So certainly he has a lot of experience with this type of development.
Okay. Thank you.
Excuse me, could I ask a question?
Yep.
Thank you. Have you looked at the other applicants? I mean, can we have some discussion? Let's get away from our objections. Let's talk about the other people. That's what we're here for.
That's what we're here for.
Okay.
Absolutely.
Thank you.
We just heard your objections first. So, we've heard the objections, two of them. And again, while we're moving on, keep back in the back of your mind whether you think those objections are real or something we have to take into consideration. So, having said that, there are other applicants. Pesci Engineering, Tetra Tech, Haley and Ward. I believe Haley and Ward was specific with the notion that they were going to specifically look at the water department.
They have a broad range of expertise, though, as does
Right.
the other firm that the sewer uses.
The sewer was Weston and Sampson.
Correct.
They are already outside consultants for the Nantucket Sewer Department. Van Ness and Asso. Jeffrey Dirk, I know that name. Are they traffic? Yeah. Beta Group, Horsley and Witten, and John Chesia. So we can just sort of go. I don't know this. I don't know how do we make this decision or not. But some of them are broad spectrum, some aren't.
Can I just clarify a point on Haley and Ward and Weston and Sampson? They do serve as outside consultants to the town on certain specific areas, but as Eleanor said, they are also multidisciplinary firms. They could do, they could handle the whole project. They wouldn't have to be restricted to just one area because they do have the expertise in other areas.
Oh yeah, Haley and Ward, right.
Haley and Ward listens.
Right.
Are we just choosing one?
Not necessarily. I mean, if we want a different traffic consultant,
I would think we would want multiple. I would think we would want, my thinking is the people who are doing work for the water company now, it makes sense to continue to use them. Same thing with the sewer department. If Vanessa's a traffic
Sorry. Go ahead.
specialty,
Yep.
I would suggest we use them.
Okay. So,
Mr. Chairman, if I may just interject one thing, which you all probably all know, but the smaller, so-called smaller firms, where there's one or two or less than 5 people, all do subcontract. Some of them subcontract to Vanessa or VHP or whatever for traffic, for instance, or other issues that are not within their specific technical purview. So, for instance, Ed Pesci subcontracts, John Shishia subcontracts. So if we don't go with one big multidisciplined firm to do everything, the smaller people could also would be able to subcontract out those other technical review services.
yeah, my personal feeling on subcontracting is why wouldn't we just contract with the other group ourselves?
We can, I just want
Yeah.
you to know that is an option that's been done before.
No, and I appreciate that.
It would save us some money, maybe, right?
Well, we're not
We're not
paying.
paying for it.
But we'll
Save them
just-
some money.
I
I'm
mean-
not looking to spend your money either.
Right.
I'm just saying. But I more to the point. Yeah,
Why
it
not
doesn't
just
make
work
any
directly?
sense.
Like,
We're going
why-
to try to work direct.
Yeah.
I mean, if we can,
Yeah.
unless there's a compelling reason not to. So Jeff, you were sort of going through the list of at least some general ideas. Wastewater and sewer. Could arguably use the town consultant, not the town consultants, but they're doing work for the town now. Do we think that's a plus or a potential minus?
I think in the case of the water and the sewer, I think it's a plus.
Because they're so familiar with the system?
That's my feeling, that those two would be a plus.
Okay, just the prior knowledge. How does everyone else feel
So that's
about that?
Haley and Ward for the water department, and then Weston and Sampson. Those are the two.
Yeah.
Yeah.
My view on Horsley Winton, despite the objection, is they did work on Satian's path, which is pretty much a success. That voted well for them. Yeah, I wasn't involved, so I don't know.
Yeah, I don't see that as a detractor. I see that as a benefit that they just went through this process. And
I didn't see any conflict. Well, having said that, if we feel that we're ultimately going to get the same service from somebody else and avoid
the appeal
process, I don't have a problem with that either. I don't see the conflict issue. Having said that, I think we would have to have a conversation, and they would have to say again, we don't have a conflict. You know, it was brought up, but having said that, we can get to that. The Sachem's Path issue, I don't see as a conflict. I mean, what would the conflict be?
Related to Sachem's Path?
They did it, yeah. So,
is there a particular concern with this project relative to stormwater and drainage? I mean, is that a big concern in that project? I've heard it come up several times, just those two areas. And
well, I think it was definitely a concern for the town when they wrote their letter that the water, the stormwater, the drainage was contained to this lot, which is, you know, what you're supposed to design. We obviously, or I certainly have no expertise.
No, I know. I just didn't know if it was like of more concern, like if there was some physical attribute of either the existing land or the project that made that something that we especially need to pay attention to, because it just has come up a lot.
Yeah, like
I think it probably relates, I'm guessing, to the impervious surface, the amount of parking necessary to support this particular application. So if it proves to be inadequate for whatever reason, then the project might need to be the applicant might need to look at the the project again. So I think that's why it's come up. So I think it's an important part of the puzzle. So having said that,
So how many do we need?
we basically need
Sewer?
site design. Storm site. The list is right in Eleanor's staff report
Right
on
here.
page
Right
6.
here on page 268.
Yeah, or page 6 of her staff report.
Okay, so site,
I mean, that's the list I'm using.
yeah.
Traffic. Okay. So traffic. Are we good with what was the one? Van
Van
Ness.
There's also Tetra Tech, they do traffic.
Who did it for Station's Path? I don't remember.
I don't remember. It was one of the two.
I think, Tetra Tech did the review for the withdrawn,
You're the one on Surfside, right? 106 Surfside.
and I believe Vanessa did safety, that was a long time ago, but I believe Vanessa did safety track, but
I think you're right.
Okay, I'm okay with Van Ness.
I'm okay with
Joey
Van
is.
Ness.
Again, let's just be clear. They're not doing the traffic study. They're
Review.
doing a review.
Of the traffic study that they submit.
Right.
Yeah.
Now, if they determine that their methodology was improper or not adequate, we might ask them to do a traffic
Right.
study.
Right.
Is that within our purview to ask them to do a new traffic study? Ilana?
You can certainly ask. You can't compel them to do studies, additional studies, but you can certainly ask them to. And in the event that you have a peer review consultant come in and review it and see what they've done, and it was just what you just said, that the methodology was improper, or the scope of it was improper, then those are all reasons for you to have a further conversation with the applicant. And it's certainly better to have that discussion early on.
Yeah.
But no, you can't require that they go out and do the studies. Certainly, you go to the town. There's no included, and you felt that it needed to be, and they refused to do it, and you really felt you had to have it. I've seen boards go and ask the town for the money to go out and do the study on their own.
Okay. So we're not there yet. We're just looking to get a consultant. So are we okay? It's Van Ness or Tetra Tech?
On the,
On traffic, transportation, traffic, and not parking. Parking would be part of it. I think
I'm not married to Vanessa. By any means, I don't.
or would you prefer Tetra Tech?
Why not?
Tetra Tech works for
Why?
me.
Why? Unless there's some reason, why do we have to go with somebody that the developers is opposed?
No, they're not opposed
They
to
didn't
Van
oppose to
Ness.
them.
They're
right.
opposed to Horsley Witten.
Right. So
No, so I'm talking about traffic, just Van Ness or Tetra Tech. Both have done work. Both, I'm sure, are eminently qualified.
And their fees are similar.
Well, the only fee thing I saw in the packet was an example from one of the one of the consultants who sort of gave us an example of their fees elsewhere, but I don't know. How do we deal with the cost implications of one?
Well, Tetra Tech here says they're $45.50 for traffic. I don't know if the other people gave a. And not that that's how we should base it. I just don't know what else to base it on.
Who did the traffic study for 106 Surfside?
Tetra Tech. They reviewed the traffic.
They
study.
reviewed it. I'd prefer.
Just the traffic, or did they do everything?
Traffic. So they took a look at the parking as well.
In what, Tetra architect, you feel, has the visibility, even though we haven't really worked with them?
No, well, we
You don't
did.
know if
They've done work on the island.
What, and Van Ness did Sachems Path, just traffic?
Yes, and they've done other, I got the traffic consultants because I'm involved with the NPDC and I collaborate with Mike Burns, the town transportation planner. So these are some of the firms that are frequently dealing with town issues in terms of transportation, traffic, parking, etc. So Beta Group.
Does Vanessa do work for the planning board?
I know that I don't know. I'm sure that they've been involved in some things. There's so much before the.
I mean, he works with Burns though on projects?
He's done some things with Burns, yes. I mean, Burns has worked with a lot of different firms.
They're actually, Vanessa is working for Remain in designing the in-town bike path and doing the traffic studies associated with that. They collaborate with Mike Burns, but.
I agree with
Go in a
Karen.
different direction.
Let's just move on then. Tetra Tech,
Yeah, I agree, Tetra Tech.
done.
Okay.
Okay. And some of these other ones, so sewer and water, we talked about using the present town, not town consultants, but the ones who are most familiar with the town systems such as they are.
I agree with that.
That would be my suggestion
Okay.
on those two, yes.
And yeah, I don't have a problem with that. Landscape, we're,
Sorry, we didn't hear, Jeff. What was that selection? I didn't hear him.
well, it would be, I think, yeah.
We would propose using Weston Sampson for the wastewater review and Haley and Ward for the water review.
Thank you.
Okay, so then the landscape, we're not there yet. We don't have a plan to review other than a general site plan. We did ask the applicant begin to develop a plan. The environmental, I sort of have it under one umbrella: site design and layout, stormwater management, environmental and zoning compliance, and overall regulatory review. So, again, if we have Ed Pesci Engineering, John Chesia Consulting, Haley and Ward, we've already done Weston and Simpson. Beta Group, know nothing about them.
Tetra Tech.
I like John Cheshire.
I'm okay with John Cheshire. But how does everyone feel?
You just liked his letter in terms of his.
I like his letter. I like that Alana's worked with him before and gives him. I mean, rather than picking someone, we kind of know who we don't want to work with or can't, or there's conflicts with. There's a couple that we have some paperwork on that we've been able to review, but having town council give as long as you're comfortable with that, Alana. I mean, you standing on the recommendation from you or your not recommendation, but your work experience with him and knowledge of him. I feel like seems like a good candidate for us, especially with the town's concern about drainage.
I can tell you that I've worked with him successfully many times in a number of towns.
Just quick, Alana, have you worked with everybody else on this group, on this list? It would just be helpful for us to know.
I can't say that I have ever done a sewer project review without it being Weston and Sampson.
Okay.
So certainly I've worked with them many, many times. I've seen Beta Group's work in the past. Haley and Aldrich I'm familiar with. I think with Haley and another person, so I'm not sure I'm familiar with that firm.
Haley and Ward. Go ahead. Sorry.
Haley and who was it?
Haley and Ward.
Yeah, I have not worked. I don't think I have worked with them. And Horsley and Witten, obviously, I've worked with many times.
And of course, you've worked with Ed Pesci. What about Beta Group?
Data groups, certainly, I have seen them work in many towns. I don't have, I can't give you any specifics. Certainly, it's a very familiar name. Certainly, I think their reputation is quite good.
Okay, thank you.
Is there an efficiency with using Weston and Sampson as the top ones, or is there a reason why we don't use them?
I would rather split it up personally, just to give multiple looks at the project.
I saw it.
That's how I feel. What are you looking for?
Data group's paperwork.
Oh, here it is. I got it.
You got it.
Yep. I knew I'd seen it. I just
35.
must have passed by it last time.
I like the idea of breaking up a little bit too. And getting some kind of fresh thoughts in.
Yeah. I mean, so we just have to decide. The applicant in an email through council said, quote unquote, we would also like to reiterate that for civil engineering review, we would recommend Pesci Engineering because he's already familiar with the project. He knows the site. He has already reviewed the plans and participated in the staff department meeting and submitted preliminary review comments, and he is familiar with the board's expectation for peer review.
Who is this?
Thanks, Peter Freeman. But that was an email from the applicant.
Well, I mean, I think it's great that Pesci did what he did, but we didn't ask him to do that.
May I please clarify?
Sure.
Okay, I was not here during the portion of the hearing where this was discussed last month, and I'm sorry for that, but Mr. Pesci didn't do anything that wasn't asked for in terms of being engaged. He was not engaged. He was
Okay.
asked to attend the coordinated review, that's standard protocol, and he was asked to witness, which is also standard protocol, soil tests. That's all he did.
Oh,
He
okay.
didn't do anything deeper than that. He did no deep dive. He had to take a look at the plans to contribute to the coordinated review, standard protocol.
Okay.
So
'Cause this letter makes it
he's
sound
not being
like-
engaged in any way, shape, or form. He knows better than to do anything without being approved as such by the board.
Right.
I work very frequently with Ed Pesci on projects, and he's here once a week, if not sometimes twice. So he's familiar with Nantucket, of course.
I'm glad that you clarified that because that was not, I think, how it was portrayed to
No,
us
I'm
or
sorry,
how
he
that
was-
email.
And he didn't hire Vanass or anything like that. What he had said was, in passing, if I end up helping the board, I subcontract frequently to Vanass for
Right.
traffic. So I would certainly recommend that. That's
So maybe
all.
maybe Attorney Freeman was confused then when he was talking about that.
I think there was just some crossed wires. I don't
Yeah.
think anybody meant to miscommunicate. It was
Okay.
just crossed wires.
But Susan, your comment makes me ask a question. What do you have against Ed working on this project?
No, I don't. I'm just saying that the way that it came up the last time at the last meeting was maybe presented to us, or at least interpreted by me, that some work was done already before we had even had a chance to talk about who we were working with or what we were doing. It doesn't have anything to do.
Yeah. I mean, it's just as important to my client as it is to you, who's working on this, because it doesn't do us any good to, we believe that the people we hired Don Bracken for a reason. He's a good engineer, but we appreciate the second look. In the end, it's probably going to benefit us because we don't want to make any mistakes just as much as you don't. It's not going to benefit anybody to have a problem over there. So the engineer, the review needs to be done.
I think any of these people on the list could do a good job. It's just which ones do we want to choose?
Right.
We want you to choose the best.
And I can't tell you what the fees are because I wasn't doing a scope of services operation with these people. I was just doing the initial outreach to check for conflicts and availability and willingness.
Well, some of them do. Some of them.
This had it
Some of them
in
have fees in there, but
Yeah, but I couldn't-
it is what it is. I mean, yeah.
I didn't get to that point.
Okay, so having said all that, is there anybody in the audience who wants to speak specifically about the consultant issue? No. Okay, so how do we feel about? Let's choose one. I mean, it's. Oh, you do. Oh, just come down to the mic and
she's on
identify
crutches.
She's
yourself.
got crutches.
Okay, go ahead.
Actually, if I can stand here, because I can say shoulder surgery, I mean, knee surgery, it's helpful.
You just have to
All right,
say your name.
Yeah, I'm sorry.
Okay. Just very briefly,
Just identify yourself. for the
Bonnie
tape.
Fitzgibbon,
Thank you.
68 South Shore Road. And my thought is to have, you said something about multiple consultants or to have, a few different peer review looks. And I just want to say, I mean, I don't know how much leeway you have with that, but that to me sounds like a very fair and sort of balanced way to look at things on this project going forward. So, I just wanted to put in my 2 cents about the multiple. I heard you say something, Ed, about maybe splitting it up or multiple consultants, and I just wanted to say that that to me that sounds like a very wise way to go. So
Thank
that's
you.
my comment.
Thank you. Just to be clear, though, we're not talking about multiple consultants to necessarily look at the same thing. In other words, we're not talking about 2 traffic consultants to look at, to peer review the same study. We're just not, I think, are saying we don't want one consultant to do traffic, storm, everything.
Got it. Okay. Yes, and I like that idea too.
Okay, thank you.
Okay. Thank you.
Okay, so back to trying to make a choice. How do we feel?
We worked with Pesci on, and was he involved at all with the 106 Surfside as well?
Yes.
And I think I hear a recommendation from Illinois. Or an endorsement.
Well,
So
it's not my choice at all.
that carries with me.
All right,
And, there isn't this conflict that I think we were thinking this was when we heard that he was already engaged. She clarified that. So there isn't a conflict.
all right. I have some level of discomfort when the applicant, in an email, recommends which engineer we should use.
Also, I think that since he's a consultant to the town, I sort of think it's nice for the planning staff to get somebody different.
So do I.
I just think it's another approach, which I think is kind of, on a project like this, would be helpful.
Yeah, it's nothing against Ed.
No.
No, I think
all.
he did a great job.
And arguably, we would get a little bit of a twofer in that Ed arguably would still be representing the town's interests at any coordinated reviews, et cetera, et cetera.
Right, so that way, yeah, I think
Yeah.
that's a great thing.
Yeah, I think it just gives us an extra
So-
level.
Yeah. If we chose him, we wouldn't get that benefit.
Right. So, in that regard, arguably we could whittle it down now to Jessia, little Beta, Horsley and Witten.
So betas, I mean, I know that what they said in the packet wasn't meant to be, there's just not a lot here
Yeah.
to know what,
I mean, again, though, Alana says they have a really good
have a good
reputation.
reputation.
So,
and then who was the other one?
Horsley Witten
Horsley
was the
Witten.
other one.
Oh, but that one, the applicants already said that they're not willing to waive their conflict on that. I think
So we should
The
just
other
forget
issue
it.
that you might see in the packet, that sheet with Horsley Witten is that they are representing the developer, Paul Keene, in Tacoma Green.
Oh,
Tacoma Green is the
Fairgrounds Road,
that Fairgrounds Road town thing.
yeah.
I love some of these names.
And that's before the planning board.
Okay, that was Horsley Witten, right?
That's Horsley Witten.
So I'm comfortable with taking them off the table for all the reasons. So then we're down to
Mr. Chesia.
Jessia,
Jessia,
Beta,
Beta. That's it.
and that's
right?
it.
That's right.
Tetra Tech is already
Jessia.
doing the,
Jessia?
Tetra Tech is doing the
Yeah.
traffic, right?
yep,
Yeah,
Sure.
I like Chesia.
I'm okay with it.
Remind once more that, I mean, I think it was, I can't remember which one of you mentioned Beta Group, and they do have done work in Barnstable, and I looked at their projects today. They've done a lot in Bristol, Narragansett, Middletown, South Kingston, which are all communities in Rhode Island that are basically, jut out into the ocean. I mean, they have the background for that kind of a geographic location, so, and if you haven't looked at their,
Hold on one second. Yeah,
haven't
go
looked at
ahead,
their
Ilana.
website, I think you owe it to yourselves and to the town to
Hold
take
on.
a look at it.
Yeah, I just want to mention that when I did call John Chesney to see if he was interested, he did happen to mention that he has done work on Nantucket before.
Yeah. Do you know where, Ilana?
I do not. We didn't get into it. I just have to send his resume and I sent it along. It didn't go into specifics. He did say that he's done projects in Nantucket before.
I, for one, fail to see why doing a project in some other town that juts out into the ocean has anything to do with peer review of what you're submitting to us.
Because the
Engineering's
apply certain rules of engineering to any project, but the rules of engineering are applied a little bit differently depending upon the topographic conditions that you encounter. I mean, the engineering for the Alps is a whole lot different than it is for Tucumã. You have to, and the more familiarity somebody has with that type of environment, the better able they're going to be able to evaluate what we put in front of them.
And Mr. Chairman, I will mention also that Engineer Chesia also is an expert in soil.
Yeah, I
think
just
I'm very comfortable with Chesia for this.
Yeah.
I am too.
To
Just
represent our interest in this.
right.
If I can ask one more question, Alana, could you hire Mr. Chesia to appear as an expert witness? Do you feel, and basically an expert witness is generally how it's done, do you feel that he can be impartial in evaluating this project, which is his role? It's not to take one side or the other.
I'm perfectly happy to answer that question, Mr. Chairman, if you'd like.
Please.
I can tell you that any time that I hire an expert, I always look, and one of the reasons why I tend to hire John Chesia when there's a civil engineering issue is because when I look to have an expert testify to a board or before a court, I want that person to testify fairly and impartially and not shade things, but to just tell the truth. Just absolutely tell it the way that it is and be able to raise the right hand and swear to it in court based upon scientific principles, not because it's something that perhaps the expert thinks that the audience wants to hear. It always needs to be clear and factual, period.
Well,
Thank you.
Thank you. But, my sentiment is, we shouldn't be hiring someone for peer review because the overall goal is to kill something. That's not right.
Nobody's saying
That's not why we're doing
Anybody
that.
up here said that?
That's what I'm feeling.
Well, you might want to reassess your feelings because I don't think anybody has stated anything even close to that.
I'll tell you why I want. I'll tell you why I want.
To get the job done.
So I don't see him being an expert in some other trial or whatever having anything to do with this. The reason that I support the Chesia firm is because of this continued focus on the stormwater runoff and drainage, and this is highlighted in his resume that he sent, that these are particular areas that he has expertise in. Beta didn't really give us that much detail in the 2 pages we have. I hear Alana saying they have a really good reputation. I hear you saying that they've done work in Narragansett and Bristol and all these other places. And those are valid points too, but I think for the area that we want him to look at, I think that he's a good fit. And I'm sure all of these firms have testified for some developer or some town or some client at some point in a trial, but I don't think that affects their ability to work.
No, I agree 100%. I mean,
So that's my feeling. Just that point is highlighted in his wheelhouse, and that's something that's going to be important to this project. So
And I
seems
think
to
when
make
you look at
sense.
his, and when you look at the comparison, he really only does site design. He only does a few things, and everybody else does sort of the whole gamut.
Right.
Yeah.
So he's specialized.
He's specialized. Yeah, I kind of like that. I think
Right.
that's a benefit to us.
Okay. I think, are we, Kieran, you feeling comfortable with the choice?
Yep.
Jim?
Yes.
So what is the scope of work for
I think it's
You would be doing,
And soils.
Site design and layout, storm water management and drainage design, environmental and landscape.
No.
not
No.
No,
landscape.
zoning compliance.
zoning compliance,
So
reg,
1, 2, 6, and 7.
1, 2, 6, and 8.
6 and
Yeah,
7.
seven.
8 is Tetra Tech.
Traffic.
No, I have a different, numeration here.
Oh, okay. So it would be site design and layout, stormwater management and drainage design,
Zoning compliance.
zoning compliance, and
Environmental.
environmental.
All right.
And then what do we?
Mr. Chairman, can I just interject in terms of the scope?
Absolutely.
One of the things that we talked about last time, and I might have been the one who was pressing for it actually, and if not, I'm going to press for it now, that there be a charge to look for code compliance overall. The general bylaws and the other, anything that may apply to this project to determine compliance. As you know, I always talk to the board about the waiver, and this is an applicant with counsel who is very experienced, and it's been my experience with Attorney Freeman in particular that he will give the board a set of waivers that will be very specific and really identify everything that they're zeroing in on. But it is always worthwhile on your side to have a peer review consultant that is examining the project as against all of the bylaw and regulatory requirements for compliance, whether it's stormwater, whatever it might be.
Right. So that would the regulatory
Regulatory
review would
Zoning
be part of his purview.
Yeah.
Okay, great.
Yeah.
Yeah, absolutely.
I was just hearing zoning compliance, and that was.
Oh, sorry,
No, that
sorry.
was just an
That was an
abbreviation.
abbreviation.
So it would be zoning compliance and regulatory review as it relates to any and all regulations and rules and regulations in Nantucket. So
Great.
we did indeed ask for the waiver list to be fleshed out and put into some sort of spread. We suggested a spreadsheet, so hopefully that'll be forthcoming. It'll certainly make peer review a little bit easier, but again, the peer reviewer will not only be looking at the waivers, he or she would be looking at everything. So okay. So I think we're settled on that issue. Architectural, we've determined nothing yet. We need to discuss whether or not, I guess, whether they've
asked for the waiver,
but I'm
going to the HGC. Is that what you mean?
yeah.
Yeah.
Do we want to
waiver, right?
Do we want a consultant as to architectural review, or do we feel confident to do it ourselves?
I don't think we need a consultant.
How do we feel about that? I mean, we don't have to necessarily decide this at this moment. I mean, we could also ask, that we have in the past, that the applicant actually goes to the HTC. They may refuse. We can certainly use the HTC as a consultant. We've done that in the past.
I mean, do we-
Mr. Chairman?
Please.
I think that the applicant said at the outset of the public hearing that they are requiring the UPDA to sit
As the
as
HGC.
the Historic District Commission. Certainly, you typically do ask that they go to the HDC. I believe you have, just as you asked that they go to water and sewer, because those are three really complicated technical areas. But I believe that the applicant has been very specific that they are asking, demanding essentially, as they have the right to do,
Okay.
40 days.
I didn't.
To be a citizen.
I didn't think we had asked nicely yet, but
I think we should ask.
yeah. So
I thought you did ask nicely.
no, I might have said if we ask nicely, maybe they will, but I'm not saying they will, and I don't. Yeah, one way or the other, I think that we could go through the HDC as giving us,
Having them as a consultant and keep
Yeah.
it in-house.
but we don't necessarily have to hire a consultant
think so.
on the architectural aspect. No?
I mean,
You're looking at me askance.
You may remember with the other 40B that was withdrawn,
Alien Wars, man.
we did end up, because the height issue with those particular structures, we did end up using an architectural consultant that was recommended by Ed Marchand, Mr. Cliff Gomer.
Oh, I
And
do
we had some
remember that.
charrettes with that, so it came to a point where that became necessary, but it wasn't at the outset.
Yeah,
That was a very different project, obviously.
that was a
architecturally,
very
so-
different project.
But it was something that evolved, so I don't,
We have a local architecture group involved in this project who's been in front of the HDC for years, so they know the drill. They know it's appropriate.
Well, it's also a large amount of work.
It is.
So it's a function of whether or not we want somebody else to assist in that work. Well, I mean, I feel a certain level of competency on the board to do the work, but I'm just bringing it up. And now, Ilana, we don't necessarily have to identify each and every. I mean, we may want a consultant at a later date, correct?
Yes, if you determine at some point during the presentation that you need additional expert, peer review, you can certainly have that conversation at that point. And I did inquire of the attorney in my office who deals with the HCC most frequently, and asked whether there was a particular expert that they used, and I did not get a name back. So my recommendation would be that you very specifically send a very pointed memo to the commission. Look, we really would welcome your input. You can even, if you think it appropriate at some point in the future, invite them in so that they can have a joint session with you. They can assemble as the commission while you're assembled, and they can respond to your questions and questions of the applicant and of the public, and that's one option that's open to you. Or they can give you a detailed report.
Joint session letter. Okay, I like that idea. Is everybody comfortable with that idea?
Yeah.
I am.
Yeah.
Okay. So, and then we talked about landscape. It's not really ready. It's I would think at some future date we'll want some help with that.
Site lighting.
Lighting.
Oh yeah, I don't have lighting
Because
on
they've
here.
asked for a lot of waivers from the lighting.
Yeah,
Yeah.
lighting. All right. We have no choices on lighting, so we'll have to maybe we can get some lighting consultant choices, but again, there's nothing to peer review because there was no plan
Right.
Right.
of the lighting, so we'll have to wait till a later date to deal with lighting. And
It certainly would be worthwhile, Mr. Chairman, to communicate directly to the applicant with regard to the landscape and the lighting plans as to when they think, ask them to, indicate when they plan to provide those sheets to you. Some applicants will say, gee, we want to do that post-approval. And so that conversation really should probably happen.
okay,
Yeah.
so what Ilana is suggesting is that I ask the applicant when we might see both the landscape plan and the lighting plan. Just to go up to, I know who you are, obviously.
Hi, Jimmy Field, the applicant. I've started that process, and so the landscape and lighting is being worked on currently.
All right, so do you think within any chance for the next meeting, or?
I think so, and we'll do
Okay.
our best to get it in before the next meeting.
Okay.
Don't hold me to it because I haven't gotten the commitment from our landscape designer, but we'll do our best.
Okay. So in the next meeting or two, maybe moving forward so we have something to discuss next meeting. because I don't think a lot of this peer review will be complete. We could potentially reach out to the HTC and see if they would like to come in for initial comments. Does that make some sense?
Well,
Eleanor?
I was going to, after this meeting, draft some memos to be signed by you that, as we would always do in this process, that will go out to the various commissions and boards, obviously HDC, Planning Board, Concom, Board of Health, perhaps, and there may be others that I'm not including at this time, requesting that they review the application within their own jurisdiction and supply us with any comments as needed and as applicable.
Okay.
So obviously, HTC Planning Board will certainly be on that list. Those memos that are being drafted, I'm in the process of getting them all ready for you to sign.
Okay, sooner the better, so that, yeah, maybe we would have, do you think we might have something back in 2 weeks?
Probably not, but typically I give them 30 days to be able to do that, so we get it on their agenda, and maybe more than one meeting where they discuss this. With the planning board, for instance, it would probably be at the end, and they may not get to it. HTC, as we all know, has very packed agendas. On that note, I have the room reserved in the event that you want to do an alternate meeting date. I have the room reserved, so
For the June 13th.
for either June 7th or June 13th from 4:30 on.
Yeah, no, we talked about that after you left, and that certainly is the intention.
I could request a joint meeting with HTC if you like, but I have to get the memo out first.
Okay. So, does it make sense to have a motion and a vote for this type of issue on the consultants, or? Yeah? Okay. All right, so
The list, do you want to make a motion?
Sure.
barring further discussion, are we ready to take a vote on that?
Yeah.
Okay. Susan?
Okay, so I'll make a motion to approve the following consultants for the following review services. So Chesia for site design and layout, stormwater management and drainage design, environmental and zoning compliance, regulatory review, and code compliance. Do we have then just keep saying them?
I think.
Okay, and then Weston and Sampson for wastewater and sewer. Haley and Ward for water. And traffic, parking, and transportation, Tetra Tech, and 40B consultant Ed Marchand.
Okay. That works for me.
Make a second.
Karam seconds it. Any further discussion? No. All those in favor say aye.
Aye.
Okay, so that was unanimous. So I think now we simply need to vote to continue the public hearing to a specific date. I will not be here June 7th, so that does
Well,
not
we
work.
wouldn't have enough information at that
No,
point.
right.
No, I'm just saying that was one of the days. Some of the thing has to do with the room and the this and the that.
So what do we just go to the 13th at 4:30?
That was, I thought, our intention. Yeah.
Wednesday, the 13th, 4:30
Oh.
in this room.
And
Wednesday
then
the
we meet
13th.
Thursday, the 14th, regularly.
Okay.
That will be in the training room.
Our regular meeting will be in the training room.
Just for this month, but next month.
Wednesday the 13th at 4:30.
Okay.
The idea being, which we discussed, was to make the meeting at a time during the day when the public might have an easier time getting here.
Yep. Okay, so I was just confused because I thought our regular meeting was the 13th. Our
No.
regular meeting is the 14th. Okay,
Yeah.
that's fine.
Okay.
Do we need any public comment too?
Public comment about what?
He did.
I did go to the public once.
About the consultants.
Consultants in
That's
general.
not what we're talking about.
We're not talking about anything
Yeah.
else today. So if I can get a motion to continue to June 13th at 4:30 in this room.
In this room, or did you say the training room?
Wait, did we didn't?
Chief meeting will be in this room.
Okay. Okay. I'll make that motion.
Okay. Lisa makes the motion. Who wants to second it? Jeffrey seconds it. All those in favor. Any further discussion?
Could you clarify who's voting on this, because one of the main members is not sitting, so I need to.
All right. So on votes like this, when everybody's up here discussing, I'm still looking for only 5 people. Correct, Alana? Okay. All right. So Mark, you want to vote?
Sure.
Okay. So Mark, Susan, Lisa, Edward,
Just a
Karen.
heads up too, I don't know if I'm gonna be back in time for either of those meetings. Still might be. So should I vote now?
You can vote on this particular motion. When you say either of those meetings,
The 13th or the 14th?
oh, well, yeah, okay. As it relates to this, the 13th. Okay. Yeah, you can. Okay, so all those in favor say aye.
Aye.
That was unanimous. Thank you. All right, so,
Can I just ask, because I didn't quite catch where the meeting was going to be.
Here.
13 and 15.
no, same room.
Okay. Okay.
Okay, so I don't think we're voting on anything else. I think that's it, right?
Okay.
Make a motion to adjourn.
So Lisa made a, thanks, Alana.
All right.
I'll talk to you later. Bye. Bye-bye.
Thank you.
Bye-bye.
All right, so the motion's been made and second to adjourn. Any further discussion? No. All those in favor say aye. Aye.
Aye.